Hi, everyone, welcome to my channel. I'm an attorney, and this is a place where we talk about HOA law. If that's not for you, just hit the X, because I don't want to waste your time, and I want to make sure that I am talking to the right audience. Okay, so let me introduce you to our next story. Our next story comes from a viewer. Hi guys, I live in a condo association with 68 units. Our board has been horrible since I moved in 5 years ago. They have no respect for us owners or tenants. Every time we ask them why they are doing something, their response is, "We can do it because we're the board." For example, we had an emergency call to fix a burst pipe in the middle of the night. We called the emergency number listed on the documents provided by the association. The company that was supposed to come fix the problem showed up 12 hours later and informed us that the board gave them incorrect instructions and the wrong address. And then the board had the audacity to fine me for being late on payment for the repair bill. They said that I was supposed to pay immediately upon request. But what was I supposed to pay for? I did not authorize that work to be done. They only told me that there was a pipe issue and that I would receive a bill in the mail. No mention of the cost. But they wanted payment immediately. Now, like I said, the bill came in the mail 3 days after the repair was completed. I called the management company and asked what the charges were for because the burst pipe had flooded 2 apartments, one above me and one below me, so I wanted to know how much it cost to fix both apartments. After going back and forth with the rude manager, she told me that the $4,987 was only for the repairs done to my unit. I asked her what the total cost for all the damages was, and she said that she didn't have that information, and that if I wanted that information, I would have to get it from the other owners myself. Unbelievable. But this happened 6 months ago. They never fixed the burst pipes. The leaks continue to drip, and they now want to fine me $500 per day, every day, until the repairs are made. The fines are capped at 18 months. I filed an appeal with the board, but they rejected it. They said that they sent me letters about the fines. Well, I never got any such letters. I asked them for copies of these letters and they denied my request. What should I be doing? Well, first of all, thank you for writing in and sharing your story. I think most people who own in a condo or own in a community probably have a story like this to tell. It seems like you've been doing everything right. You've paid your share of assessments. You follow the rules. You don't have any violations. And so this is a real travesty that this board is treating you this way. So here's what I would suggest. First, get yourself a lawyer. I know that money is always an object. But when you're dealing with an HOA, if you have to go to court with them, it's always better to have representation because judges generally take a dim view of people who represent themselves in court, especially when they're going up against a collection agency or an HOA. So if you have to go to court, definitely get yourself a lawyer. Now, before you get a lawyer, there are some things you need to do. Number 1. Write down everything that you remember about what happened. The more detail, the better. And then write down every communication that you had with the association, including text messages, emails, phone calls, letters, any kind of communication. Print those out. If it's online, screenshot it, save it somewhere, put it in a folder. Also, I would suggest that you go and inspect your unit and take pictures of the damage that you're reclaiming. Here, the association is saying that the burst pipe damaged your property. Well, you might want to take pictures of that. make sure that they're aware of that damage, especially if it's caused by their negligence. And then keep track of every communication, every email, every letter, everything that goes back and forth between you and the association. That's really important. Now, what I'm thinking is that you need to sue the association. You need to sue the association for damages, but you also need to stop the fines. You can't stop the fines unless you get an injunction. An injunction is a court order that says the parties must do something or refrain from doing something. In this case, I'd say that you need an injunction to stop the fines from accruing. If you can stop the fines from accruing, then that will prevent the fines from being added to your assessment and becoming a lien on your property. That's something you really want to avoid. So getting an injunction early on is very important. And then suing them for the damages that they've caused to you is also important. Here, I would suggest that you look at the Articles of Incorporation and the bylaws of the association. There may be a provision in there that talks about how much notice the association needs to give you before they can start fining you. This is very common. Most associations have to give you a certain amount of notice, like 30 days or 60 days, maybe even 90 days, before they can start fining you. I know that this rule exists in Florida. I'm not sure about other states, but you need to check your governing documents. If they did not give you enough notice before they started fining you, then that could be grounds to set aside the fines altogether. In addition, I would also look at whether or not the board voted on these fines. Usually, you need a certain amount of votes from the board to approve fines, so if they didn't do that, then that could also be grounds to set aside the fines. Another thing I would look at is whether or not the fines are actually a lien on your property. Most states require the fines to be recorded in order to be a lien on the property. So look at the public records and see if the fines have been recorded. If they have, then that is a serious problem because that means that they can foreclose on your property to collect those fines. So that's something you need to be careful about. I would also suggest that you try mediation. Mediation is a good option, because most judges like to see that you tried alternative dispute resolution before you went to court. In mediation, you and the association sit down with a mediator, and you try to work out your differences. It's confidential. It's less expensive than going to trial, and it's a good way to resolve the dispute without going to court. Finally, make sure that you preserve the statute of limitations. Statutes of limitation vary by state. In Florida, I believe it's for years. That's how long you have to sue the association after the fines are imposed. So make sure you keep track of that deadline. You know, I have to admit that I'm biased. I think that courts should laugh at HOAs whenever they can. I mean, I remember a case that involved a man who planted palm trees, and the HOA made him cut them down, and the judge ordered the HOA to pay for the trees. The judge even inspected the trees to make sure they were healthy before ordering the HOA to pay for them. I love stories like that. I wish I had one to share with you, but I don't think this story will end that way. Instead, I think you should expect a lot of pushback from the HOA. They'll probably file a lawsuit against you. They'll probably file a lien against your property. They'll probably try everything they can to scare you into paying the fines. But stick to your guns. If you're right, then you have nothing to worry about. And it sounds like you're right. I hope that this story has a happy ending. I hope that the judge laughs at the HOA and sides with you. And I hope that this story will serve as a lesson to other HOAs who think they can bully people around. Thanks for watching.